v. Louisiana, respectively.
However, the most recent precedent set by Ramos v. Louisiana in 2020 established that juries must be unanimous to convict a criminal defendant. In the majority opinion, Justice Gorsuch described the Sixth Amendment right to an impartial jury as including the right to unanimous jury.
He additionally explained the Jim Crow era origins of the lack of a unanimity requirement. Reacting to the passage of the 14th Amendment and other post-Civil War actions, a convention was convened to, quote, reestablish the supremacy of the white race.
One of the democratic agencies this group chose to weaponize was the jury system. The state of Louisiana, joined by other southern states, systematically limited the ability of Black men to participate in juries. This, combined with the power of juries to return non-unanimous verdicts, allowed the voice of Black jurors to be all but silenced.
Because of the racist origins of non-unanimous juries, unanimity is an essential part in ensuring due process and equal protection under the law, especially for those who have been historically disenfranchised.
In his famous paper, Some Kind of Hearing, Judge Henry Friendly laid out the most important aspects of procedural due process. Included on that list was an unbiased tribunal, meaning it is part of the procedures the government must follow to ensure that everyone is being treated fairly by the government.
In a process dominated by legal professionals, jury trials provide the voice of the people. Without them, biased judges could return verdicts that are unjust. While some argue that biased jurors threaten the carriage of justice to defendants, the larger threat is a biased judge, whose bias has the power to impact more than just one case.
Ballou v. Georgia found that even a smaller jury can be tainted by bias and be less effective than a larger panel. However, issues of bias do still plague the jury system. And, as in the story of 12 Angry Men, even one juror can have a large sway over the verdict of a trial.
In their ideal form, jury trials are a significant example of the continued use of founding ideals. In colonial America, trial by jury was the people's most powerful check on the government, as demonstrated by the Zenger case. Despite sufficient evidence, the jury refused to convict, establishing the precedent that jurymen are to see with their own eyes, to hear with their own ears, and to make uses of their own consciences and understandings.
The founders brought this idea to the American founding, citing in the Declaration of Independence the deprivation of the benefits of trial by jury against British rule.
Additionally, juries were so important to the founders that it is the only topic appearing in the Constitution thrice. The Sixth Amendment, Seventh Amendment, and Article 3, Section 2 all guarantee the right to an impartial jury for the accused, protecting those who are most vulnerable to the government.
In Federalist 83, Hamilton further reiterates this statement, writing that juries prevent arbitrary impeachments, arbitrary methods of prosecuting pretended offenses, and arbitrary punishments upon arbitrary convictions.
The vicinage clause, included in the text of the Sixth Amendment, is a lasting example of the legacy of classical republicanism in American government. Founding era philosophy emphasized the importance of community involvement in government. Its compulsory nature ensures the maintenance of the founders' desire for the people to be involved in their communities and in their government.
These examples, among others, highlight how founding principles such as rule of law, due process, separation of powers, personal liberties, limited government, and consent of the governed not only stand at the core of our jury system, but cannot be practiced to their full extent without the jury system. Thank you, and we stand ready for your questions.
Thank you. You essentially talked about the composition of the jury. In terms of the pool, do you believe that the voir dire process is a suitable process for ensuring an impartial, unbiased jury? Why not?
I would argue that although the voir dire process does have some flaws, I think that it pretty much does the best it can do in removing any obvious bias from the jury, such as racial prejudice, things like that.
One of the important ideas to consider when looking at the judiciary system is obviously it has flaws, but we can't let the perfect be the enemy of the good. There are improvements that can be made to voir dire and to the jury selection process because it is easily manipulable by prosecution and by both sides really to create a jury pool and to create then a jury that can largely decide the case without even deliberation.
Taking a look at a case such as Perkett v. Elam, which is going to say that at step 2 of the Batson test, the justification only has to be race neutral and not even minimally plausible or even persuasive. And so there you can kind of see how they could, prosecutors or even the defendant or the defense can basically use that as a tool to still weed out jurors, and that could still lead to a biased panel.
So are you in favor of eliminating preemptories?
We are not in favor of entirely eliminating preemptory challenges. There are definitely positive examples in which they can be used. We do, however, express concerns with.
What are those positive aspects that are sufficient to outweigh the potential for abuse?
I think this is the process where you're getting the most impartial as possible. And so, for example, you look at a case such as Pina Rodriguez v. Colorado, where even though they have a no impeachment rule, that they still allow a defendant's testimony or a witness's testimony to be included, even though it might not typically be allowed. And so because this kind of demonstrates just how these checks can be sufficient in dealing with issues such as race and prejudice within the jury system.
And there are examples where bias is obvious enough in voir dire that peremptory challenges can be applied. Like if a juror makes an obviously biased statement, we just face concerns more with where appearance-based ones are used to maybe say that a juror might look disheveled, and that might be used more often for like people of color and discriminating against appearances that are deemed like unsuitable by a certain group.
But again, that sounds like yet another reason not to have preemptory challenges. Why have them at all? I mean, what good purpose do they serve?
I think that the biggest thing that these processes allow is just on the face getting rid of the obvious people that are going to be biased towards the defendant and that are really going to have an overall impact of the trial.
This summer, I was able to observe a case, and it was a case of child abuse, and one of the jurors from the get-go said, I have a 6-week-old son at home. I simply can't be unbiased. And so in that case, they were able to do a quick strike because there was simply no way that man had any chance of being anything but biased.
For cause. I mean, they had to give a reason, and it does sound like a really good reason. Again, I'll just try one more time. Why? I mean, it sounds like all preemptory challenges where you don't have to give a reason, they sound like a disaster. So why do we still have them?
It simply is a case in which people in power have decided that it stays in place, and we don't, as a panel, believe that there really is all that much of a purpose for them. There are very few benefits that we can see, if any at all, and much more often than not.
Gotcha. Okay, thank you.
Great, thank you. So in your presentation, the first example you gave of the importance of the jury in the founding era was the Zenger case, which was a case of jury nullification. Is jury nullification the most important function of the jury? How does that fit in with our overall concept of rule of law?
While it is an important aspect of the jury, I would say that jury nullification should be practiced with caution and is definitely not the primary point of a jury. I would argue that the main purpose of a jury is to be the people's check on the government when the defendant is at their most vulnerable to the government.
However, you do see jury nullification being used to essentially have more justice. For example, during the time of fugitive slave laws, you see northern juries using jury nullification to essentially acquit the defendant who is either said that they were a escaped slave or those who are helping that process. So you see, because they believe that is an unjust law, they're using jury nullification in order to have a more just verdict.
And going off of what Sydney said, I think it's important to err on the side of caution with jury nullification, as we don't want to see this used too often. This is established in the case of Sparf and Hansen v. United States, which established that judges do not need to inform the jury panel of their right to nullify a jury.
I guess, how do we draw that line, right? How do we determine what is good or bad jury nullification, and how do we prevent the bad jury nullification? Should we give judges the ability to override a jury if they're nullifying a verdict in an improper way?
The way that we can sort of prevent negative jury nullification is to have as diverse of a jury panel as possible. We see issues of jury nullification coming in when you have largely biased juries, such as in the case of the murderers of Emmett Till. In this case, it was an all-white panel that was able to say, yes, there is evidence. However, we don't believe that the law is just, because they were able to justify the killing of an innocent 15-year-old. And so if we have a more diverse panel where more discussion occurs, then nullification will be more difficult to occur, and therefore that will serve as a check.
And this all just goes back to the benefits of voir dire, as we were talking about before. If at first glance, the first jury pool selected is not a representative cross-section of the community and is not a representative of your peers, then this is just a way to further ensure diversity of thought within the jury panel.
You seem to suggest then that the selection process may be one of the issues. If the selection process is an issue, how do we remedy that to make sure you have a diverse jury pool for that veneer?
I think the biggest way we do this is just going back to the Sixth Amendment's guarantee of a right to a jury of your peers. We've seen later the courts interpret this to mean a diverse group of nationalities, ethnicities, races. It doesn't just mean that women are to be tried by women and African Americans to be tried by African Americans, but rather a general consensus of the community.
Another thing we could do to improve this would be to increase jury pay. Currently in our home state of Virginia, jury pay is $30 a day, and this negatively impacts hourly wage workers and other people who won't be compensated adequately. And so if we were to improve this to a standard where a blue collar worker could afford to take the time off of work to serve on a jury, it would both incentivize this practice and improve sort of the stigma surrounding jury service.
Also, currently, in order to measure fairness, most states are following an absolute disparity test. And this typically has around like a 10% threshold, I believe. So in states where you have minority representation below that, you could essentially have a pool that is still considered fair and reasonable without any of that minority opinion. So I think moving towards possibly using a comparative disparity of risk test, where you can essentially measure just how that representation is affecting the results, then that is another way to fix this the jury system.
How about how many of these principles apply to civil cases? When we're talking pretty much in the criminal context, but of course there is a guarantee in civil cases. Would you apply these same lessons to civil cases, or would you make adjustments? If so, what?
So the largest difference between a civil and a criminal case is the fact that in a criminal case, one of the jury's jobs is to protect the people from the government. This is less so applicable in civil cases because the government isn't actively fighting against the defendant. In a criminal case, the government has said, we would like to see this person convicted, where in a civil case, this isn't present.
However, we do see some similarities between civil and criminal trials and juries. For example, Colgrove v. Batten upholds that between 6 and 12 jurors is an acceptable number in civil cases, which is 12 is obviously the standard for criminal cases.
I think we're just about out of time, so enjoy the moment of respite. I saw the 1 minute sign earlier, so I don't want us to jump into a question and just find ourselves disconnected by
I will. Plea bargaining, the death knell of the jury system or not? Go.
Definitely, it brings down the jury system for sure. We see mandatory minimum sentences incentivizing people to take plea deals. And can I finish?
I have to let you finish. Yeah.
Incentivize these plea deals to settle outside of court. And then additionally, on the civil side, we see with mandatory arbitration as well as damage caps that this really limits the monetary compensation available. And this leads to either not pursuing the case at all or settling outside the courtroom.
Thank you. And sorry, Judge Chin.
No, don't apologize. They were ready